Hi guys, thank you for attending our webinar, Preventing Wage Underpayment in Your Franchise. This webinar is hosted by LegalVision together with Now Actually, and we hope you find it both insightful and practical. Now, just to some housekeeping matters before we begin, you will all be emailed a copy of this webinar recording after its completion, so don't feel the need to take notes as we go. If you do have any questions, we'd love to answer those at the end. There should be a chat box at the bottom of your screen, so just submit them there. And finally, everyone will be emailed a survey after completion of the webinar, and we'd really appreciate it if you could complete that. So myself and Jenna are hosting today's webinar. By way of introduction, my name's Emma Jervis. I head the franchise and leasing practice at LegalVision and have done so for coming up to 8 years. My team and I represent both franchisors and franchisees across all industries and all different sizes of franchise networks. And I'll hand over to Jenna to introduce herself.
Hi everyone, welcome. So I'm Jenna Paulin. I run a outsourced HR company. We service clients from a national perspective across Australia. I personally have got 10+ years as a HR generalist, and we have a team of generalists that serve small to medium-sized businesses. And one of our specialities is the franchise sector. So we support franchisors and franchisees, making sure that they comply with their obligations. And we act as an internal department. We act as if we're an internal department, but from an external model. Thanks, Emma. So we'll move on to what today's session is going to be about. So we're going to be talking about the wage system and how complex it is and what laws you need to apply, what the Vulnerable Workers Act is and the consequences of getting this wrong as a franchisor and a franchisee. Also, what the risk of non-compliance is in relation to underpayment of wages. So what can go wrong, and some tips in how you should promote compliance within your network, your franchise network, what you can put in place to make sure that underpayment does not occur. Then we'll finish off with some questions. So as Emma mentioned before, please feel free to add them in the chat box as we go, and we'll answer them at the end. And then we'll finish up with a closing about the LegalVision Pro membership. Thank you very much. So we will start off with what laws do apply to wage compliance. So as you're aware, the Fair Work Act is quite a complex piece of legislation, and the employment landscape in Australia is known to be one of the most complex in the world. So we're not playing in an easy field. So basically there are several different pieces of legislation that come into when we're looking at wages and how to apply them. The overarching piece is the Fair Work Act. Then we've got modern awards. We've got the Superannuation Guarantee Act, and we've got the Long Service Leave Act. So what we're going to focus on for this little part is the Fair Work Act and the awards and how they apply. So basically, from an employment perspective, we have a tiered system whereby the Fair Work Act is the overarching piece of legislation, and from that we have what's called the National Employment Standards. There's a set of 10 standards, and then under that falls the awards. Now there's several awards, and that's what dictates what we must pay our franchisees, our employees, to make sure that we're in line with legislation. So the biggest thing is, how do you identify the right award for your business? So as I mentioned, it's a really complex piece of legislation, the employment one. There is 121 modern awards. What one position might be classified in Award A might change in 2 years' time as Award B, depending on what's happened in the court system. And so that makes it really hard for businesses to keep up with what award certain job roles come under. So awards are based on either your industry or your occupation that you're operating. They then fall down to what are the roles and responsibilities of the position that you are trying to identify which award. Then you've got some positions that are award free, which adds another layer of complexity. So as you can tell, it's quite a complex system. With 121 modern awards, no one is an expert in any of all of these. It's very difficult for even the experts to understand which award is applicable. So to determine which award that your business falls under, you need to identify the roles and responsibilities of the job. Then once you do that, you identify what classification within those awards they fall under. And then to add another layer of complexity, some roles are going to be award free. So for example, if you're a marketing manager or a HR manager, they are generally considered award free. So you've got no award to fall back on. So it's not a set and forget situation. So within the awards, there's many different terms and conditions under each clause, and the sections that you're going to want to be looking at within the award to determine which award is right for which position in terms of the wages is you're going to be looking at the ordinary rate of pay, the overtime, allowances and penalties. These sections will determine what you need to pay your employees. Now, we need to make sure from a legal perspective that you do not pay below what is outlined in these awards. Each award is connected to what's called a pay guide, and that outlines these elements, as I've mentioned, the ordinary rate of pay, the overtime, allowances and penalties. As a business, you can operate above the minimum, but you need to make sure that if changes come into place in relation to the actual dollar figure, you need to do calculations to make sure that you're continually better off overall to determine that your rate of pay that you're paying your staff is in line with the minimum or above. For example, you may have a business, and within that business, you might be operating 2 or 3 different awards. So you might have a fitness business, so you might be a franchise in the fitness industry. You might have your personal trainers, for example, come under the fitness industry award, but then your office administration staff from a head office perspective or also within the studio may come under the clerk's award because that covers administration. So it's really important that you determine the right award for the position. It's not one blanket rule, this award for my business. Making sure that you do regular reviews of the award structure from a pay and wage condition perspective is really important to ensure that you are paying your employees correct, because underpayment comes with a lot of consequences, which we'll talk about further in this presentation. Over to you, Emma. Thank you.
Thanks, Jenna. So guys, I'm going to delve a little bit further down into some really important statutory provisions as contained in the Fair Work Act that Jenna spoke about, and they are what's generally referred to as the vulnerable workers provisions. It's really important from the outset that in particular franchisors recognise and appreciate that by virtue of these provisions, they can be liable for a breach of the workplace laws, even if they've not entered into a contract with the relevant employee, never met the relevant employee and had no dealings with the relevant employee. If that employee is underpaid, that the franchisor can be liable. Now that liability was strengthened by introduction of the Fair Work Amendment Protecting Vulnerable Workers Act of 2017. At a high level, for today's purposes, the most important introductions were the introduction of higher penalties for what's deemed a serious contravention of workplace laws, extending the liability, including penalty provisions for breach of workplace laws to franchisors, and including a carve out, if you will, to that liability if a franchisor has taken reasonable steps to prevent that contravention. This came about largely as a result of the 7-Eleven scandal, where there was widespread underpayment across the franchise system as part of the government's response to that. And I'll talk through the 7-Eleven scandal a little bit further. Now, looking at the precise wording of the Act provides that a franchisor will also contravene the Act, so in addition to the franchisee employer, if they knew or could reasonably have been expected to have known that the contravention or a similar contravention would occur. And I think if we really consider that precise wording, it becomes obvious that franchisors can no longer turn a blind the words reasonably have been expected imparts an expectation on a franchisor to be active in their franchise network in promoting compliance. Taking that one step further, a franchisor will not contravene those statutory provisions if they've taken reasonable steps to prevent the contravention by the franchisee. As I said, this was part of the government's response to the 7-Eleven scandal. The purpose of introducing this bill into Parliament was largely to encourage franchisors to ensure that their franchisees are legally compliant, but also as a protective measure for the vulnerable workers, being generally the young workers or the migrant workers. The Parliament recognised that franchisors simply have deeper pockets, and therefore that's an additional way to enforce back pay in instances of underpayment. When the bill was introduced into Parliament, an explanatory memorandum was released, which provided that the very purpose of the bill was to address increasing community concern about the exploitation of vulnerable workers, including migrant workers, by unscrupulous employers, and respond to a growing body of evidence that the law needs to be strengthened. That evidence likely included that response to the Fair Work Ombudsman's report as a result of the 7-Eleven scandal. Now, I mentioned that franchisors won't be liable if they can demonstrate that they've taken reasonable steps to promote compliance. So what are reasonable steps? That term, reasonable steps, isn't defined in the legislation, but guidance has been given through parliamentary speeches, and there's a really comprehensive and helpful guide that's actually published by the Fair Work Ombudsman. It's clear from those sources that what's reasonable for one franchise system will differ from what's reasonable for another, and be based on a number of factors. The law does make clear that in determining if a franchisor has undertaken reasonable steps, a court may have regard to all relevant matters, including, so this is not an exhaustive list, the size and resources of the franchise, the extent to which the franchisor had the ability to influence or control the contravening franchisee, any action the franchisor took to ensure the franchisee had reasonable knowledge and understanding of the requirements, the franchisor's arrangements for assessing the franchisee's compliance, the franchisor's arrangements for receiving and addressing complaints, and the extent to which the franchisor's arrangements with the franchisee encourage or require franchisee to comply with the Fair Work Act and workplace laws. I mentioned before a guide that's been published by the Fair Work Ombudsman, and in that guide they talk through these considerations of the court, and they've also identified 4 overarching principles that will apply to all franchise systems and which should be considered by franchisees and franchisors in developing a response to the vulnerable workers provisions and promoting workplace compliance in their businesses. Those overarching principles are firstly to set expectations. From a franchisor level, that can be firstly having clauses in the franchise agreement that require compliance with workplace laws, but also going a little bit further, and it's quite commonplace now to have a chapter in the manual, for example, that will set out what is required of a franchisee to ensure that these workplace laws are complied with on a daily, weekly, monthly and annual basis, and having clear step-by-step procedures in place. The second overarching principle is to educate and train. Franchisors now commonly, either themselves or through engaging a third party, provide ongoing education. As Jenna mentioned, the award system is incredibly complex. It's subject to annual review and update, so that education has to be ongoing. The third principle is to monitor compliance. Commonly, that's done by a franchisor firstly providing franchisee tools to monitor their own compliance and undertake their own self-audit, but also undertaking audits across the network. And finally, it's to take further action. It's really important as a franchisor, if an employee of a franchisee approaches you, hey, I'm being paid $10 an hour, as opposed to the applicable award rate, that the franchisor can't just flick that back to the franchisee and say, hey, it's your employee, deal with this. A franchisor now must take action. That action can be in the form of an audit, if there is indeed a breach that's found, issuing a breach notice and requiring rectification, and ultimately, if that rectification doesn't occur, to proceed to terminate the relevant franchise agreement. Some of those practical steps that tie in with these overarching principles, Jenna will talk through at the end of our webinar. So I'll hand over to Jenna about what the risks are from a practical perspective of non-compliance.
Yeah, so as Emma mentioned, Fair Work can come knocking on your door. So just because you're a franchisor and the franchisee is technically the employer of the employee that may be getting underpaid, they can come knocking on your door as well. So what does non-compliance look like? What can Fair Work do? You can get a claim that is submitted from the employee who claims to be underpaid, and that claim can cost $74 odd for an individual to lodge. So if a claim is lodged, what can it do to your business? Not only can it cause stress and anxiety to the business owner, that can be the franchisor and the franchisee. It takes a lot of time and energy to work through these claims. It can be damaging to your brand, which I personally think is the #1 thing here. And it can also cost you a lot of money, because if you are found to be underpaying, you not only may have to back pay, you may be fined through a penalty aspect that Emma spoke about before. So Fair Work can come knocking on your door through a claim that is submitted by the employee. They could get an anonymous tip-off from an employee or a member of the public that could trigger an audit that the Fair Work want to come and investigate your business. Now, it could be a particular franchisee, or it could start as that and then venture out into the wider network, and the franchisor then has multiple franchisees that is becoming known to be underpaying. So the thing is that even though you're not the direct employer, you need to make sure that your franchisees are compliant, because the audit from a tip-off or a claim, or you may just come up as a red flag through Fair Work, or it might not even be a red flag, it can be just spot audits, given there's so many examples out there now, that can really cause damage to your business in those elements I spoke about: time, money, stress, anxiety, and brand damage. So Emma's going to give you some live examples of cases over recent years of what's actually happened to businesses when they have been deemed to be underpaying employees. There is no longer excuse, "I didn't know." There's enough information and support resources out there to make sure that businesses do not underpay. And then following that, I'll talk about some things you can actually put into your business to avoid these things happening. So over to you, Emma, to give some live examples, please.
Thanks, Jenna. Sorry, guys, I've got a plane going overhead. I hope you're not hearing that. Inner West Life.
No,
I think it's important to actually apply the law to practical examples to really understand the consequences for businesses of breaching these workplace laws. So what I want to do is just talk through some real life examples of what's happened and what the consequences were for the relevant parties. I've mentioned it several times. The big one is obviously the 7-Eleven scandal. That was everywhere in the media. It was scrutinised heavily by Fair Work Ombudsman, by relevant government departments, and it got a lot of attention and really put this issue on the agenda of payment to vulnerable workers in particular. Now, this all started, if you will, with a Four Corners story and a Fairfax media report, which outed the systematic wage underpayment by 7-Eleven franchisees across the network. The conduct that was subject of the report occurred in a period from about 2012 right up to the release of the report in August 2015. I just want to read what I thought was a really important quote from that report. This was from a whistleblower franchisee who said that head office is not just turning a blind eye, it's a fundamental part of their business. They can't run 7-Eleven as profitably, as successfully as they have without letting this happen. So the business is very proud of itself and the achievements and the money it's made and the success it's had, but the reality is it's built on something not much different from slavery. Pretty damning words and a pretty big problem for the franchisor. Following the release of this Four Corners story and the media publication, Fair Work Ombudsman conducted an incredibly thorough investigation across the entire network. and found that there was many different forms of underpayment. There are examples, for example, of franchisees paying, say, $20 an hour to their workers, but requiring $5 cash back from their workers. There was widespread non-compliance with the award provisions. There was falsification of employment records. There was complete non-payment of superannuation. In essence, every law that Jenna spoke about at the start of this webinar was broken across the franchise network. The report from the Fair Work Ombudsman did attribute some responsibility to the franchisor, noting that the franchising arrangement and the way this entire network worked was such that it was almost impossible for stores to make a profit unless they underpaid staff. They also noted that the franchisor here benefited from the wage underpayment insofar as the ongoing fee, as it commonly is, was based on a percentage of profit. And obviously that profit was bolstered by not paying staff what they were entitled to. There was no court decision, if you will, based on the 7-Eleven scandal. Instead, the Ombudsman worked together with 7-Eleven and they entered into what's called a compliance agreement, which detailed the practical steps that the franchisor had to take to promote compliance and ensure that history didn't repeat itself. Penalties were imposed, however, against individual franchisees under the penalty provisions contained in the Fair Work Act. Between September 2015 and February 2020, 7-Eleven, and by that I mean 7-Eleven as a whole, both franchisees and the franchisor, backpaid more than $176.3 million in wages, interest and superannuation to 4,043 current and former franchisee employees. So 176 million is a substantial amount of money, but even more importantly, I think, is the brand's reputation, which took a battering as a result of this incident. So that's a very large scale example of the consequence of wage non-compliance. Looking then at a smaller scale example, there was a case in Perth. A franchisee owned 2 cafes trading under the Hands franchise brand that employed young and predominantly migrant workers. So workers that that fit squarely within that definition of what a vulnerable worker is. Now, the Fair Work Ombudsman actually prosecuted the franchisees back in 2017 as a result of wage non-compliance, and penalties were issued and back payment was ordered. But they did it again. So the Fair Work Ombudsman conducted a further investigation and commenced Federal Circuit Court proceedings in 2021 as a result of further non-compliance with the wage laws. Ultimately, the court heard that the conduct of the franchisee satisfied the criteria of a serious contravention, which I spoke about at the start of the webinar, and said that their conduct reflects a cavalier and entirely unacceptable approach to core legal obligations. Employers must be deterred from engaging in similar conduct. So the franchisee, because they had been found liable for serious misconduct, were potentially facing penalties 10 times the standard penalty provisions as contained in the Fair Work Act. Ultimately, they were ordered to pay $191,646, which for a small 2 cafe operator is a substantial amount of money. And in addition, the general manager of the relevant outlet was also ordered to pay $38,394. Importantly, these penalties were imposed in the context of underpayment amounting to around $5,000. So it wasn't a huge quantum of underpayment. Obviously, it also had to be underpaid. But the point of the significance of this case is the breach of these serious contravention provisions, and the fact that the Federal Circuit Court is willing to hand down these much more significant penalties. The next case I wanted to touch on super quickly was that of Yoga Berry. It's a more historical case. It occurred in 2016 before the vulnerable workers provisions were introduced. And it's just demonstrative of taking a different path to get to the same outcome. So Yoga Berry was subject to a Fair Work investigation in 2016 concerning its World Square outlet in Sydney. That investigation uncovered 15 contraventions of the Fair Work Act and applicable fast food industry award, resulting in underpayment of wages, loadings, penalty rates, unlawful deductions, failure to engage for minimum shifts, and failure to pay superannuation, amongst others. It received, being the franchisee employee, a $75,000 fine. Importantly, however, the franchisor was also deemed liable here, and they were issued a fine under what is called the accessory provisions of the Fair Work Act, which basically say if you are an accessory to a breach, you can also be liable for that breach. Because of the involvement here between the franchisor and the franchisee parties, and that the franchisor had taken an active step in managing this particular Yoga Berry store, they were also penalised. The quantum of the penalty was around 25 grand in that instance. In addition, they were ordered to undertake practical steps to promote compliance, undertaking audits, educating their head office, those sorts of things. A more recent example that you've probably seen in the media concerns the Subway franchise. There's been a lot written up about the underpayment across the franchise network, and then again an investigation undertaken by the Fair Work Ombudsman. In this instance, the franchisor was not prosecuted, and there was never an allegation, if you will, of a franchisor being in breach of the vulnerable workers provisions. My theory, and this is not based on any report of Fair Work Ombudsman I've been able to find, is that the Fair Work Ombudsman, in undertaking their investigation, actually believed that Subway had satisfied its reasonable steps criteria. And I say this because Subway were very vocal in responding to what was released in the media about this underpayment scandal. They made clear that they took the issue very seriously, that they took no hesitation in breaching and ultimately terminating franchisees that didn't pay in accordance with the law, that they had no knowledge that this was happening, and had they had that knowledge, they would have taken those steps. And they were also very proactive in showing what they did do across the Subway chain to promote compliance. Notwithstanding that, there's no doubt that, again, there's been huge reputational damage for the Subway brand as a result of this negative media. So it demonstrates that even if a franchisor is not deemed legally liable, there are still huge consequences. So how do we avoid those consequences? Jenna?
That's a very good question. So we speak to many franchisors, and as we've spoken about today, a lot of people don't understand the Vulnerable Workers Act. They either don't understand it or they're not aware of it. It's not new, but as Emma said, 2017, it hasn't been around forever. So what people aren't aware is the liability can come back on the franchisor as much as the franchisee. So you as a franchisor have a duty of care to your network to make sure that you have the right practices and approaches and processes in place to make sure that you remain compliant. So the biggest thing is making sure you have some type of HR or employment law support in place to cover your network. That's to cover the franchisor, head office, HQ, whatever you call it within your system, and the franchisees. It's recommended that this support comes in twofold: advice, so verbal support, I've got a situation here, I'm unsure how I need to pay them, etc., and through documentation. So having all this in place, and I'll talk about some examples shortly, will help go towards minimizing your risk of non-compliance when it comes to wages within your network. The best thing is to focus on an educational approach. Communicate legislation changes and best practice for your network. So as I spoke about before, there's the minimum wages that we must pay a certain individual. However, you can go above that, but making sure that you have a best practice stance for your network, having it consistent. A recommendation is not to just let the franchisees take their own path when it comes to payment of wages and the HR employment law side of things, because you have no control of it. And you should have some control given the Vulnerable Workers Act. So education is the best step. provide accessible resources to your network to utilize to minimize these risks and to increase their knowledge. Remember, when they sign up to you as a franchisee, they are signing up generally because they love hospitality or the fitness or whatever industry they're in. They're not signing up as people leaders, HR experts, knowing how to run the people aspect of their business, and that's where they rely on the franchise system to support them. So as a franchisor, we're recommending that you have structured documentation and a support line in place for your franchisees to reach out to you. Now, what does some documentation look like? As Emma mentioned before, the manual. So we have the franchise manual. We say have another layer, have an HR operational manual, making sure within that it says what you need to do from a compliance, how and why. So it's step by step. So it's like a dummy's guide on how to manage the HR function in your business as a franchisee. Create templates for your central system, like employment contracts, HR forms, onboarding checklists, offboarding checklists, recruitment, probation. Set the structure up to avoid non-compliance of any HR matters, especially wage compliance. As Emma mentioned, there's a yearly review of the minimum wages set by Fair Work. So that should mean that you should review your wages at least yearly within your network to make sure that you're in line with that. Have position descriptions, have policies in place, because that all goes in line and connects to the wage. You want to implement a culture of an annual audit. Now, when people see audit, they see scary, red flag, nasty. It doesn't have to be. Take a proactive approach. Take it as an opportunity for learning and development. Cover the compliance aspects, but really talk to your franchisees and make sure they understand their duties and responsibilities as a business owner. This reduces the risk of underpayment because through these conversations, you are going to be making sure that they are paying their employees correctly. They're giving pay slips, they're paying their superannuation on time, they're providing leave, they're paying the penalties correct. And if it's all set from head office, it should flow consistently and relatively easily through your network from the franchisees down to the employees. Because this type of audit highlights issues before they might become major. They might be just minor. A lot of the time, what we find in the underpayment aspect of employment, it's not always deliberate. It's through lack of knowledge and education that people are underpaying their staff. So it's important as a franchisor, you have a duty and an obligation to educate your network, and through that education, provide the tools and resources to make sure this doesn't happen. Have a channel that the franchisees can reach out to someone to get HR advice, to make that general people management a lot easier. Be proactive rather than reactive, because sometimes when things get hard, we bury our heads in the sand. So if the franchisees know they've got some type of support within the franchise network, they will reach out and use it. Now, a lot of franchisors believe they're not big enough to have a HR department internal, or it's not our responsibility. Hopefully we've covered it is your responsibility to a degree in today's session. So if you can't, because more heads is a lot of cost from a business perspective, if you can't afford to have an internal structure, consider getting third-party resources. That will reduce the cost but cover your obligations. That will make sure that you as a franchisor don't have to be the expert, but you're engaging experts to help support your network. That could be payroll experts, it could be HR experts, it could be legal, it could be a combination of all. But having that aspect within your system, it's just as important as the marketing function and the operations. It's just a lot of people aren't aware of how important it is these days, but hopefully through the information we've provided today and some live cases that Emma has spoken about, you can see how easy it is to come unstuck and be done for underpayment. Yes, it is the responsibility of the franchisee, who is the employer, the director of the business, but it is also the responsibility of the franchisor to make sure their network, which is the franchisees, are paying correctly. And having this structure in place that I have spoken about here will help reduce any underpayment going on and any liabilities that may pop up down the track, or if there is a liability, we will catch it sooner rather than later by having all this structure in place. So hopefully that gives you some practical tips on what you can implement into your network. You may already have them, you may want to tighten them up, or it might be a time to start thinking about what HR employment law structure do I need to put in place to protect myself and my network and my brand, because as we know, with today's social media, word can travel pretty fast. So that comes to the ends of the formal slides. I'll hand it back over to Emma before we get into some Q&A.
Thanks, Jenna. Just quickly, guys, we have a publication at LegalVision on how to prevent wage underpayment. It's not a franchise-specific publication, but it's a very helpful guide to firstly understanding legal obligations and then the practical steps to ensure compliance with those legal obligations. That can be downloaded from our website. Now over to a Q&A, and as I said before, if anybody has a question, feel free to pop it in the chat box. Bear with me while
we've had a few, Emma, come through.
Yeah.
So some of them we
sorry, go ahead.
Sorry, some of them we may have answered, but we'll cover off. I'll kick off with the first one if you want, Emma, and you can do the second. So someone has asked, are we recommending we carry out an annual wage audit for all employees across the franchise network? Short answer, yes, to some degree. So again, it comes back to the culture and the processes that you put in within your network. So having an annual audit is a really good initiative to put in place, but it doesn't have to be just focused on the wages. Take it from the holistic people aspect and HR and have that conversation and provide the education. Having that audit, it's not a mandatory legal obligation, but having it is best practice, and it's going to reduce the liabilities for you as the franchisor and the franchisee if an underpayment arises. Because as we said, a lot of the time people are underpaying not deliberately, just uneducated and made simple human errors. Emma, do you have anything to add to that one?
No, I guess from a practical perspective, it's also important that in the event that you receive a complaint, that triggers an audit, particularly if the complaint's from more than one employee of a particular franchisee, or it's of a pretty serious nature, i.e. cash payments as opposed to compliance with the award. You should have an internal system to audit that quickly to see if there's any truth to the claims.
Perfect.
Just moving on to the next question, does the audit then provide Fair Work with the power to investigate all aspects of the franchisee relating to Fair Work 10 employment standards? Short answer, yes. The investigative powers of Fair Work are incredibly far-reaching. And I apologise, I keep coming back to it, but if you read the 7-Eleven report, it shows you just how far-reaching they are. In that case, they had complaints about certain breaches, i.e. these cash payments that were occurring, the payment of flat rates as opposed to award payments, but their investigation went a lot further than that, and it uncovered things that the employees themselves perhaps didn't appreciate, being non-compliance with the strict payslip rules, for example. So short answer is yes, Fair Work has very, very broad powers of investigation.
And lastly, we've got another question. How does the franchisor control or gain visibility to when a franchisee control pay rates to their employees? That's a really good question, because that is the million-dollar question. How do I, as a franchisor, make sure my franchisees are paying correctly, because they're the ones that process the payroll? And in not all depends on your system, but a lot of franchise networks, they don't have the visibility. It is the payroll owner, which is the employer, which is the franchisee. So it comes back to putting in place those control mechanisms, making sure that you have accessible pay grades available, pay charts available for your network to access. So you're giving them the right information at least. Doing those annual audits, making sure that you have questions in there around wages and payroll and processing, doing your own spot audit. So you might want to do spot audits yourself, like Fair Work would do, but within your network. Having it as an educational tool. I know I keep talking about education, but it comes down to fair and reasonable, as Emma mentioned earlier in the Vulnerable Workers Act, and making sure that you're doing all the reasonable steps to reduce your liability if a situation does come. You want to have structure and evidence, so Fair Work, that you have done everything you possibly can as a franchise system to minimise risk. So having these initiatives in place from a head office perspective that all your franchisees must follow will help with having control. But short answer is you don't always going to have actual visibility of the payroll. Have you got anything else to add there, Emma, from the legal aspect?
I guess from a legal perspective, it's really important that that control is incorporated into your franchise agreement. And you actually have operative terms whereby the franchisee has to give you access, and that can include real-time access to specific software programs, and has to entitle you to come in and audit. They should be clauses in every franchise agreement. So just checking your franchise agreement and making sure that these points are covered should be a first step.
We've had another question pop in, which I think it's probably best for you to answer, Emma. If you are not terminating the franchise agreement immediately after finding that there has been an underpayment, how do you check that the issue has been rectified? For example, do you simply ask for a financial statement? And how often should you review this to ensure that it's no longer an issue?
Okay, great. So I guess taking a step back, it's important to recognise that after finding there has been an underpayment, a franchisor won't generally have a right of termination. Here we have to go back to the franchising code, which provides that in the event of a breach of the franchise agreement, and hopefully here we have a clause in the franchise agreement requiring compliance with laws, a franchisor has to issue a breach notice, has to set out what's required to rectify, and has to provide a reasonable time to rectify. There are circumstances in which a franchisor can terminate immediately. They're called the special circumstances under the code, and that can include fraud. So if there has been widespread, for example, non-payment and falsification of records, you might trigger those fraud provisions, entitling termination with 7 days notice. Otherwise, you have to go through the typical breach notice regime. Once that's occurred, the breach notice itself should actually set out what exactly is required for rectification. Ordinarily, it will be that they have to be subject to an audit. They have to follow written directions resulting from that audit. They have to provide some sort of ongoing report for, say, a 12-month period following the audit's completion, and those sort of practical measures. But really importantly, they should all be set out in the breach notice so that if that rectification steps don't occur, the franchisor is actually legally entitled to proceed to terminate. Any other questions, guys? Excellent. We'll wrap up shortly. So as I said at the start, I head the franchising and leasing group at LegalVision. We act for both franchisors and franchisees. We do offer LVConnect Pro membership, which is kind of an all-you-can-eat legal service. It's really great for those in the franchise game. We provide advice not just on franchise agreements, but can also provide advice on employment issues, for example, which are obviously very relevant. If anyone's interested in LVConnect Pro, we can certainly offer a strategy session, and you just need to tick yes in the survey that's going to be circulated after today's webinar. But thank you all for attending. Jenna, thanks for hosting with me. I think that's it for today.
Thanks, Emma, and thanks everyone for joining. We appreciate it. We hope you found it.
Thanks. Bye.